thank you very much. Have a great meeting.
Thank
And I'll hand it over to you, Aaron, now.
All right. Thank you. Hi, this is Aaron Saladay, the chair of the Colorado Mortgage Board of Loan Origination. Today is the January 15th, 2025, and it is exactly 9 a.m. This is a public meeting of the Colorado Mortgage Board of Loan Originators, and we will now call this meeting to order. Let's begin by having the division director perform a roll call.
Aaron Saladay,
Here.
Shirley Phelan,
Here.
David Williams,
Here.
Josh Brodbeck,
Here.
Natalie Lawson.
Here.
You have a quorum.
Thank you very much. Next order of business, were there any discussion that we need to talk about the November 2024 meeting minutes?
No.
No.
Can I have a
I'd like
motion?
to make a motion. I'll make a motion to approve as submitted.
I second.
it.
Second, all right. There's been a motion and a second to approve the meeting minutes of the meeting November 20th, 2024 of the Colorado Mortgage Loan Origination Board. Let's have a vote. All those in favor say aye.
Aye.
I am also an aye, and the motion passes. Next on the agenda, I'd like to move to executive session. And this is a Colorado Mortgage Board loan origination. It is January 15th, 2025, and the time is 9:01 a.m. This is a meeting of the Colorado Mortgage Board loan originators. I move that the board enters into executive session pursuant to Colorado Revised Statutes, section 24-6-402 3A II, to receive legal advice and training on policy matter A, loan officers paying real estate agents for referrals, and attorney general matter A, training regarding license applications with criminal convictions. I move that the board also enter into executive session pursuant to Colorado Revised Statutes, sections 24-6-402 3A II, to address legal questions concerning the legal requirements for discipline regarding investigative matter B, complaint 2024-891, investigative matter C, complaint number 2024-1049, and to discuss and receive legal advice on the pending legal action, OAC case number MLO 2023-003. Can I have a second?
I second.
All right. And so let's do a vote. All those in favor say aye.
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 I am also an aye. The board is exiting the public meeting to convene to a closed executive session conducted remotely.
We're going to the other site, right? Shoot.
Correct. Make
Yes,
sure
sir.
that you shut off your video and also your audio on the Zoom meeting.
All right.
Morning, everyone. Fire department, fire chief. Yesterday, understand your desire to return to your community. However, significant
Is everybody back in?
Here,
I think we're all back in.
I don't see Natalie yet.
Okay, we'll wait.
Hmm.
Wonder if she got kicked out.
We're gonna try reaching out to her.
Thank you, Director Waters.
Everyone should be back now.
Thank you. The time is 9:51. The board is now back in open session. And we're looking at policy matters. Director Waters, take it from there.
So board members, the item on your agenda for policy matters is about loan officers paying real estate agents for referrals. And I think board member Saladay brought this up. So if you want to lead off the discussion, that would be helpful.
Yeah, it's been something since I'm duly licensed. Actually, someone had come up to me and actually said to me that they could actually pay me on referrals as a loan officer, as a referral for referring someone over to them. And I reported to him and I said, this can't happen. That's why we have licenses in Colorado. You can't do that. And he said, oh no, we can definitely pay you on your referrals over to us. And I said, you can't do that because I'm not your employee. He goes, oh, well, you'd have to be an employee. And I said, that's the key to it. And I want to basically go on record. I know, I think we had read this out in the past, I think it was in the last year or so, because it has been something that's come up quite often lately. And it goes back to RESPA. And it's the reason why we all have mortgage licenses is that we can get paid on an application because we're transacting the process. As a real estate agent, I should get paid to actually send a loan to a loan officer that does their job and closes my loan. My payment is I had someone that did their job and actually we got the loan closed. So I wanted just to kind of go over that again with you because I actually, again, like I said, someone actually came up to me and was like, hey, I can pay you. And that's why we have to have a license. You can't, just like some of the stuff we're going to talk about today, you can't get paid on a loan that closes if you do not have a license. It's against the licensing law. So I just wanted to see what your guys' thoughts were on that and open it for discussion.
I think it kind of falls under the same guidelines like with advertising, right? And, are you paying for advertising and what work are you doing? I think the key issue in that is what work are you doing for the payment of a referral, payment for advertising or whatever. You can't just arbitrarily. I think it's kind of being used, unfortunately, for an inducement to generate business and not necessarily for any work that's being done.
Absolutely. I feel like it's kind of skirting the system.
Exactly.
Yeah, and I think like we had been talked about a little bit, it's going to come back to the frequency and timing of the payments. Is it every 2 weeks? Is it every month? Is it just like a normal paycheck, or is it, hey, when this closed, I got paid and it's different amounts? So anybody listening, I think really um, if you're doing and practicing this, if it comes in front of the board and we see these payments that are going to be totally different all over the place, that's something we're going to look at. But if it is a consistent payment, I'm sure that'll be something that we would take into consideration as well.
And it's like mortgage companies setting up marketing agreements. The key is, here's the work, here's what you're doing in your payment, and it's got to be consistent, and it's got to be logical in terms of the amount that's being paid with as it relates to that, whether it's an office rental or advertising, whatever. It can't be just arbitrary amounts.
Absolutely. Absolutely. Thank you for that clarification.
Agreed.
So,
So give me an example of when it's okay and when it's not okay, so that I can make the distinction.
So in a situation, I think that it would be okay is if someone actually was doing, let's just say it was marketing for real estate services, and someone came in and they're getting a paycheck every week or every 2 weeks for the time that they're working. If they're working 10 hours a week, and that, let's say 10 hours a week was $20 an hour, they get $200 a week or whatever that may be. If they're getting one paycheck in 1 month and there's 2 months where there's not one, that to me is a red flag, and it's totally different amounts, because it's not what they're trying to do is hire people as a W-2 employee. W-2 employees have a steady income, not based off of each individual transaction.
Okay.
And or
Okay.
like a random bonus, I would think would be the same. Like if you're getting minimum wage every 2 weeks for your time, and then all of a sudden there's this large bonus when you closed on a real estate deal that you referred over to them, that would be an indication that they were being paid on that for the referral, not for their services.
Okay.
And if there was a bonus structure in play, there should be a guideline that's, in print that says, it's not verbal, this is the agreement, here's the matrix that, the bonus would come into play,
Right.
not arbitrary.
Absolutely. So
Yep.
So am I understanding this correctly? Basically, what we're saying here is that just giving a referral is not acceptable.
Correct.
Okay. Yeah, I agree with that.
I mean, I guess let me expand on that. A referral to a loan officer is totally fine, but it's the payment of the referral
Yeah,
that is not.
Right.
thank you. Yes. The money involved, yes.
Right.
So, okay.
Agreed.
All right. Any other discussion on that? Are there any other agenda items for next meeting that anybody wants to put on? No?
Not I.
All right. All right. I think we'll turn it over to public comment.
Good morning, board members and members of the public. If any one of the attendees that is present today would like to speak to the board, please select the raise hand icon in the Zoom platform and we can unmute you. Looks like we already have one board members. Jacob, you should be able to unmute yourself. Please identify your name and any party that you represent, and have at it.
He didn't even try to pronounce my last name. Yeah, hi there. I'm located here in Scottsdale, Arizona at Lone Depot. And I just want to say that, first of all, thanks for hearing me out here. I submitted all of my package and documents, and I think that I may have filled out something wrong, and that's why I went through this process. So I would just still want to, I'm not really sure if maybe, I can tell other new hires here, maybe not to follow the steps that may lead to a webinar like this, and maybe do a better job in the beginning part of, the fingerprinting, ask, making sure that you're inputting the data correctly on the questionnaire for Colorado for DORA. So maybe I can make some notes to tell other trainees here if they made a mistake like I did. That was all.
Well, thank you. Appreciate your coming on and, providing that advice for future applicants.
Yes, thank you, Jacob.
Just by your guys' cells.
Is there anybody else out there that has a public comment or wants to talk to the board?
If anyone else is interested in speaking to the board, again, please click the raise hand icon, excuse me, in the Zoom platform. Board members, seeing none, I'll pass the meeting back over to you for investigations.
Good morning. I'm sorry about my voice.
Oh, no.
The first complaint matter is 2024-1954. September 19th, 2024, the respondent entered a guilty plea to felony menacing, real simulated weapon, a class 5 felony. The respondent was ordered to complete a 1-year deferred sentence, 1 year of supervised probation, and a fine of $1,033.50. The fine has been paid and probation is ongoing. Possible violations include 1210-713-1P, 1210-713-1N, and disciplinary recommendations are diversion, a $500 fine, probation to be concurrent with a criminal sentence, and if deferred criminal sentence is not successfully completed by September 19th of 2025, the license would not be renewed. And Investigator Martinez can answer any questions.
Thank you. I'll open this up to any questions or discussion that the board may have.
I have a question. Was there any other criminal history that was uncovered with this licensee?
No.
No? Okay. My only hesitation I wanted to express to the rest of the board is that in addition to not disclosing this person's conviction, when I was reading through the police reports and what have you, this person was also dishonest with the investigating officer about facts that were easily verifiable. So I wanted to throw that out there to the rest of the board for consideration and see what y'all thought.
I agree with you.
I agree as well, and I find it a little troubling that he was leaving his office. So that would mean that he's going into the office and into work with, weapons. And then brandishing them right after work. It just seems a little too close for comfort, in my opinion.
And I don't recall, was there anything about anger management that he had gone through? I don't remember that.
Yes. And he has completed an anger management course as well as provided several letters of reference.
And he is currently licensed in other states right now, correct?
I believe so. Let me double check for you.
And while you're looking that up, he did pay his fines and stuff right away, right? There wasn't a collection agency or anything after.
Well, and this was very recent.
Very.
So that's a concern to me too, is this is not a, stupid thing that happened in the past. This is very recent.
speaking only for myself, given that this was a first offense, I'm okay with diversion, but I would like to see us consider increasing the fine to the maximum, which I believe would be $2,000. Probation concurrent with criminal sentencing, I think I'm okay with that as well, but now would be our opportunity to send a message, and I think that's the best way to do it.
The board members, it's a max fine of $1,000 for the first administrative action. And I don't believe he's had any prior, so the maximum fine would be $1,000.
Oh, I apologize. I thought it was 1,000 per violation.
Per violation, yes. Sorry.
Okay.
So there are two, so we could do 2,000 because there are two violations. Okay, thanks for the clarification.
And looks like the state, other state licensures, it's only Colorado.
Okay.
Yes.
I mean, I'm kind of in agreement with Josh in terms of, a misjudgment without prior to, if there were prior to convictions that have a probably a different answer, but definitely a lack in judgment that we all could be guilty of from time to time. So I think it's a good message and he's on probation, so he's definitely having some reporting responsibilities on what's happening.
I agree with all of you. I think, as a gun owner, if you're going to actually have it with you, it is of the utmost importance to make sure that you are controlled and in a good position in that. So I am absolutely agreeing with all of that as well. The diversion, upping the fine as well, and then probation, and then deferred, have it run along with the current sentence as well. So.
I guess I do have one question. I guess the rules call for if there's a plea of guilty for a felony within the immediately preceding 7 years, then it would just be an automatic deny. Is that not the case?
Board members, sorry to interrupt. Just briefly, so this is a deferred judgment. Deferred judgments, the way they kind of operate is there's a plea that is entered, and then a plea of guilty that is entered. And once the probationary period is completed, that plea is withdrawn and the case is dismissed with prejudice, so there is no conviction. In this case, I believe the probation, if completed successfully, would be completed in September. The average time to take a case to trial in OAC, for example, a revocation, would be at least a year. So timeline wise, something to keep in mind.
Board members, basically, I mean, once he the recommendation is to help encourage him to complete his criminal sentence through the criminal courts. And if he does that, then that guilty plea will be rescinded. So I think you have some flexibility, and Anthony can correct me if I'm wrong, about not the black and white revocation. But if he doesn't complete his sentence by September, what we would do is recommend, and this is part of your recommendation, that you refuse to renew him. When you revoke a license for a criminal conviction, it's going to go beyond that 7 years. If it falls into that 7-year category for a felony, that revocation is forever. It becomes a forever issue. So this is kind of a kinder way of dealing with the criminal sentence, but also encouraging him to complete his current criminal sentence.
Got it.
I agree with the ESP referral. To me, I think the fine should be higher, just like we were talking. But it also does note that if the deferred criminal sentence isn't successfully completed by September of 25, they will not renew the license. So that would basically give further decision-making on that portion of if we decide to do that too, so.
Would that come back before us again at that point? Or does it just automatic in the disciplinary action?
If you'd like us to bring it back to you, if he fails to complete his probation, we can definitely do that, and you can kind of reaffirm your decision to refuse to renew. It's at your pleasure.
Okay. I think.
But it would automatically be, would not be renewed, and the process would just follow through with the non-renewal, correct?
Yeah.
Would
if
that let
that's
him
what you vote on,
continue
we'll
to
say
practice through the balance of the year then?
he would be able to practice until the end of the year. But like Anthony was telling you, if you decided today that this was egregious enough that you wanted to revoke the license, if he elected to take it to hearing, he would still be able to practice through the end of the year and renew his license, because chances are it would not get scheduled for hearing with the Office of Administrative Courts in 2025, and would probably extend into 2026.
Okay.
So I'd like to make a motion that we accept staff recommendations, with the one amendment being to increase the fine to $1,000 per violation, which would come to a total of $2,000.
I second that.
All right, let's have a vote on that. All of those in favor say aye.
Aye.
I am also an aye. The motion passes.
The next one is investigative matter 2024-891. The complainant alleges that she worked with the respondent in obtaining a mortgage for the purchase of a home while the respondent's Colorado mortgage loan originator license was expired as of December 31st, 2023. An email provided by the complainant shows that on April 16th, 2024, the respondent communicated rates and terms of a potential 2-1 buy-down loan. While most applications in the file list a licensed loan originator, there were 6 drafts of the loan application contained in the file that were electronically signed by the respondent on May 16th, 2024, and lists the respondent as the loan originator. A loan estimate and notices of intent to proceed contained in the loan file also list the respondent as the originator. Despite the loan closing on May 20th, 2024, the respondent's company has no NMLS call reports filed for the 2024 year. The respondent confirmed that he was unaware of the expiration of his Colorado mortgage loan originator license, and that he did not communicate rates and terms to any other Colorado borrowers. His license is still currently expired. Possible violations are 1210-704, license required, and disciplinary recommendations are a final agency order and a fine of $1,000. And Investigator Martinez can answer any questions.
I just had a couple of questions related to some details on this, and this is more directed to those of you in the business. So is a 3-2-1 buy down typically disclosed, outlined on a disclosure, or not? Because there was a claim that 3-2-1 buy downs are not disclosed, do not have to be on a disclosure, and I'm just questioning that.
They are disclosed on it generally, in my experience.
Yeah, so typically we have to disclose everything, and if anything does change, we have to do what's called a change of circumstance. And so anything that would be a 2-1 buy down or an arm or a fixed or, terms, even like a 10, 20, 30-year term, has to be disclosed, agreed upon, and signed as well.
And there's
Okay,
an official document outlining that they sign as well.
Okay, thank you. And then there was something about refunding the origination fees back to the borrower, and a statement that the respondent made that it was illegal to do that. So I was just quite curious, just for my information and the public's information, is that typically illegal or is that done?
You can basically switch compensation in the factor of what you have. We typically have a contract with a lender and they pay us X dollars. You can't be paid more or less in that, but that's called what's called a lender paid. That's where the lender pays the loan officer / company. If you go to borrower paid, which you can do, you basically can state your own compensation and the borrower has to pay it out of pocket or through the loan. So you could definitely do that. In this situation, you could have done the loan for free, for sure.
Okay, thank you.
So that was one of my questions. That was actually a great lead in, Investigator Martinez. Was there ever a change of circumstance that you know filed with the lender? Because there were so many different LEs and CDs and stuff
I
bouncing around.
don't have a change of circumstance in the file that was provided.
I also didn't see a locked in loan estimate. Was there ever a loan estimate which stated this is now locked in?
Yeah, there is a locked-in estimate. There were several drafts, but yeah, there was a locked-in estimate. Give me 1 second.
And did that lock-in agreement show that it was a 30-year fixed rate?
Yes, yeah, that is correct. The 2-1 buy down didn't appear on any of the disclosures. However, there is an email where the loan originator is explaining it. The email doesn't appear to indicate that it was actually a guarantee, but he is explaining it, yes.
And could you just share what page the locked loan estimate was on
Yeah, I'm sure I'm digging that
when
up.
you find it?
1 second, yeah. It's a lot to go.
And again, he was doing unlicensable activity.
Yeah, the primary concern was that the license was not active at the time that he was communicating. So
Yeah, I think somewhere in here he said he was a loan manager. And yeah, no.
Yeah, he was definitely doing licensable activity, discussing rates, both with the borrower and with the real estate agent, obviously.
Yeah, right.
Mr. Investigator Martinez, I did have one more question for you. Did you ever go into any further and request to have copies of anything that, like when I do loans, I pull credit at the time I do that. So anything from January through a certain time frame, did we ever receive anything to show what credit company he used and anything that was accessed?
no credit report was provided. So we do not have evidence of who the credit report servicing company would have been. So that is certainly something that we could follow up with the lender on. But no, there was no credit report information provided with the transaction file.
Thank you.
Well, I think unfortunately in this case, because his license has expired, we have limited
Jurisdiction.
right. And I just want to go on public record as saying that I think that the respondents' activities were not what's the word? They were just not good. I mean, even if he had been licensed, this is not what I would consider ethical behavior and proper conduct for a mortgage broker. Unfortunately, because he's not licensed, we can't do anything about that. But I just like that on record.
And I do have just one observation, just for those of you that aren't in the business. So he ended up to permanently buy that on the right. He paid 2.151% to do that, and a 2-1 buy down is typically right around 2.3. So I'm not sure what the thought process was there. Were we able, I can't recall, were we able to confirm that the company that he had locked it in with, that they did change that buy down?
So I did follow up with them, and what they explained, let me open the email, was that no, that program was actually not canceled. And I'll give you the exact verbiage from the email that was provided. Okay, yeah. So specifically, what the compliance officer said was that the program had never been terminated. We've only added it on an existing product so far, no buy down specific products. So he basically said that no, the program was never terminated.
So then he
Uh,
lied to everybody,
That's
right?
that's
So
for you to decide. That's for the board to decide. I can't make a decision on that, but
it
given the
appears
information.
that was it.
Yeah.
That would be a correct conclusion.
Yeah. I have a question, Paul. Was the other individual named on the documents, the other loan officer, was he contacted?
So we did not speak with him. Essentially, he was licensed at the time. The concern there was A, that the borrowers had said that their point of contact was our respondent, and B, that our respondent was not licensed. But the other individual was actually licensed. So him performing the duties of a loan originator wouldn't have been viewed as a compliance issue on our side.
And was there any discussion as to why it kept going back and forth between the two?
Yeah,
names?
so the loan originator had explained in the interview that he believes that it was his system that was generating the company name and his name on the applications. But yeah, he does cite in the interview that he believes that that was an error in his internal system, not the lender system. Basically, once the file is originated with his company, it's sent over to the lender for them to further continue processing the file. But he believes that was an error from his system. Um, uh, I don't know why a system would auto-populate a loan originator whose license is not active. Typically, if a system identifies that a license is not in place, it can't be applied to an application. But I'm not sure why it was that this occurred with his system specifically.
So one more clarification question. Did the company that he originated the loan with pay the commission to him or to the other loan officer then? Do we know that?
That actually I was not able to verify. It appears that the compensation on the closing disclosure, I believe it lists the company.
Yeah, the broker fee went to Link. Ooh,
Yeah, the company. Yeah, exactly.
Company.
Which is ultimately our response is the president of the company. So he would have been responsible for the company collecting that payment.
Which would
So it went to
also,
the respondent.
That's
One could assume.
but we don't know for certain on that because it's possible that the respondent may have also paid the other loan originator.
Yeah.
So that piece of it I was not able to verify with the respondent. Certainly we can follow up with him to see. But yeah, as far as what was on the closing disclosure, it was actually the company that was paid, not an individual loan originator.
And if I recall, the real estate agent confirmed that all his conversations was with the respondent, correct?
Yeah, the borrowers did as well.
Correct.
They said that the respondent was their primary point of contact. Yes.
Okay.
and ultimately too, the lender, every year we have to verify our license. And anytime we do a renewal with lender, we have to submit that stuff in there too. So the lender should have known that there was not a license for this individual as well.
Right.
Definitely.
Yeah, usually that's caught on the front end with the lenders. I've seen some scenarios where the lender will identify it and immediately contact the broker and say, hey, we need to get a licensed person so to work this file. But I don't know why it wasn't identified on the lender's side for this particular transaction.
Were you able to confirm his company is a viable licensed company?
Yes, yes, they are registered in the NMLS.
Okay.
However, we are running into issues with the fact that no call report was filed for 2024 for quarter 1, 2, 3, or 4. But we know for certain that this loan closed in 2024. So yes, the company is in place. Call reports. It appears that there's been an issue with those getting filed.
So
Is
lots
the
of
company, sorry, go ahead.
no. Go ahead.
Is the company still licensed or do we know if it's still around?
So let's see. Well, he is not actively licensed, obviously, but I do believe the registration is in place. I'll check the NMLS registry right now.
And I only have one more question.
Mhm.
There is no application pending for the respondent, correct?
No, I didn't find a new application in the system for him or a new set of fingerprints. So I don't know if he's planning on reapplying here. But no, it doesn't appear that there's anything in place right now that indicates that he's going to be trying to get licensed again, or that
Thank you,
the
President Martinez. Thank you.
yeah. And I'm just trying to find you the company information. 1 second.
So being an unlicensed loan officer, what ability do we have for disciplinary actions, if any?
Cease and desist. And I think I'll let the attorneys handle that.
You've also imposed fines in the past,
Okay,
usually $1,000 for unlicensed activity.
okay.
I mean, that's what the recommendation is, and I think that's the maximum that we can do.
Okay. I'll definitely see that.
And then are we able to flag it in case he applies in the future that we would deny in the future?
So based on disciplinary action, if he applied in the future, we would probably bring it to you for a licensing decision.
Got it.
And
And
Natalie,
we-
I believe the fact that that staff is recommending an FAO, that will be permanently attached to this former licensee's record. So that would also, if staff brings it to us, correct me if I'm wrong, Marcia, but if staff brings it to us, we'll also be notified that all of this happened because there's an FAO on the former licensee's record. Am I right?
The FAO itself is not the determiner of whether it gets brought back to you. We would bring it to you just because he's got prior discipline.
Okay, understood.
And are we able to recommend public censure in this case or no, because he's not licensed?
I believe that you can do public censure.
Okay. Well, I would
I
be in
agree.
favor of that too.
And it looks like company registration is still active
That's interesting.
in the NMLS registry.
So taking into consideration the discussion, I'd like to make a motion that the board accept staff recommendations and in addition, add a public censure and then refer the matter to, I believe this is the right way to do it, correct me if I'm wrong, but refer the matter to the AG to send a cease and desist letter. Is that an allowable motion? Correct me if I'm wrong.
So board members, we can actually send the cease and desist without it getting referred to the Attorney General's office. And with your
Okay,
budget issues, we
I
need
take
to
it back. Yeah, let's go ahead and send a cease and desist. And then along with the other recommendations for the motion. That's my motion.
I second that.
Well, before we do that, I believe Attorney Lally said we could not do public censure since he was not licensed.
I believe the discipline is the discipline is limited to section 711. I think 711(8). Let me double check the statute site is correct. The board members, 713, which includes censure, deny. The terms of that language states that the board has the power to impose fines, deny a license, censure a license, place the licensee on probation, order restitution, order payment of actual damages, suspend or revoke a license when the board finds that the licensee or applicant has performed, is performing, or is attempting to perform actions. Since this individual is neither a licensee or an applicant, that section 713 would not apply. The fine language section that empowers the board to issue the fines is 711(8). And that provision has two parts. One, it enables the board to issue a cease and desist order. That would be 8 subsection A. And then subsection B states that the board, in addition to any other penalty that may be imposed pursuant to this Part 7, any individual violating any provision of this Part 7, which would include 704, or any rules promulgated pursuant to Article 10, may be fined upon a finding of misconduct by the board. I believe that is the statutory basis for the fine. I will say that a final agency order is public. It is a public record already. But that is the language that I was looking at and citing for what the board's authority is for individuals who are not licensed or applicants, because 8B specifically refers to individuals.
Okay, so let me retract my motion and I will make a new motion that the board accept staff recommendations and in addition, send a cease and desist letter.
I second the motion.
All right, let's take a vote on that. All those in favor say aye.
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 And I am also an aye. That unanimously passes.
The next one is matter C, complaint number 2024-1049. During the course of working with the complainant on a purchase transaction, the respondent directed the complainant to pay a total of $23,500, various individuals via wire transfer, as fees to process and close the loan. When the loan failed, the respondent also directed the complainant to make a payment of $15,000 directly to her. The respondent's bank records reflect that the money was wired to her account by the complainant. The respondent assured the complainant that the fee was refundable if the loan did not close. However, no refund has been provided. The complainant explained that he lost $7,500 in earnest money as a result of the transaction not closing. The respondent admitted to not having a surety bond or errors and omissions insurance in place at the time of the transaction. Possible violations include 1210-713-1Q, 1210-713-1B, 1210-713-1I, 1210-713-1M, 1210-713-1V, 1210-713-1Y, and Rules 2.6, Rule 2.7, Rule 5.9, Rule 5.6C. Disciplinary recommendations are public censure, a final agency order, revocation, a fine of $8,000, referral to law enforcement, and $15,000 in restitution. And Investigator Martinez can help answer any questions.
I think there's going to be a lot of questions on this. I'll start. I do have a couple questions for you,
Yes.
Investigator Martinez. In reviewing this case, I was wondering, is the seller related to the buyer's agent? They have
That was asked. Yeah, so we're a complaint was open against the buyer's agent, so we're looking into all of that. A lot of the information that we obtained in this particular investigation was specific to the mortgage piece of it. But based off of the information that's in the report, a complaint against the buyer's agent was opened, and we will be looking into all of that.
Excellent.
Thank you.
I actually don't have any questions on this one. I was pleased to see that the investigation and the supporting documents were so thorough, and that it appears to me that staff recommendations are really for the maximum amount of discipline that could be justified in this instance. I mean, I was prepared to recommend to the board that we just accept staff recommendations.
I agree.
Just one quick question.
Yes, please.
Did she give back the 15,000 to him?
Um,
Or is this?
no. So
Go ahead.
I just spoke with the respondent yesterday, and what was explained in the report, I had also cited some emails communication, I believe from late October or early November, where the respondent reached out basically saying, hey, one of the lenders wants to refund the complainant, but he needs the bank routing information for the complainant. I responded basically saying we absolutely will not provide that information, but you have the borrower's contact information. You can reach out to him directly and arrange the refund. So I didn't hear anything back from our respondent after that email chain, but she called me yesterday and basically let me know that that lender supposedly still wants to refund the money to the borrower. However, the borrower also refused to provide his direct account information and said, you can provide me with a certified funds cashier check. I'll accept that. And apparently, per the respondent, the individual that she was speaking with, that the lender or with the lender, did not want to provide a cashier's check. So I outlined to the respondent that, okay, so essentially, the money was paid to you, but this lender is supposedly going to refund the borrower. However, won't provide a certified funds cashier check, and will only accept the borrower's bank routing information as the means for providing the refund. So that was all discussed with the respondent, but per the respondent, the lender will only or doesn't want to provide the cashier's check, and essentially wants to use a direct wire transfer as the means for refunding the borrower. And obviously, with what the borrower's experienced, I don't think providing his account number and routing information is something that is even remotely considerable at this point.
Oh, I agree. Yeah, I wouldn't give them any information at all with what he's gone through.
Right.
I mean, there are just no words for this whole thing. I did want to put on the public record that I noticed that on the respondent's bank statement, which was Exhibit 16, which was her bank statement showing the $15,000 that she received. There's a note on there that says, she claims she sent it on to the loan company, but there's a note on there that says 6,000 withheld as per cut.
Yeah.
Which was, I mean, that's exactly what was written, and clearly she was taking money out of this too.
I'd also like to note that there are 4 other borrowers that were copied on some email communications where one of the lenders is saying that he's going to refund them. I did speak with one of the borrowers, and I expect to. I'm sorry. I spoke with 2 of the borrowers. One of them I couldn't complete the interview with because of the language barrier, but I did send the interview questions to him via email, translated them into Spanish, and sent them via email. So we very likely will be hearing from more of the borrowers. Uh, the one that I emailed, specifically, I see in the bank records that there's a $20,000 payment to our respondent from this individual. Again, I tried to complete the interview with him, but because of the language barrier, we're going to have to do everything in writing. So I expect to hear from him probably before the end of the week. Essentially, the questions that I sent over were the same ones that we had asked our complainant. I spoke with another borrower. This one is a recorded interview in the report. And specifically, what he explained is that he paid the respondent $8,500. However, his transaction was not specific for the purchase of a property in Colorado. It was in Texas. And he also expressed that he did not have any any property under contract at the time that he had paid the money to our respondent. So there's no transactional documentation that he would have been able to provide. But still wants to try to see if we may be able to pursue something because she was in Colorado when the payment was collected. So perhaps something that we refer to law enforcement, but for that borrower, the property was in Texas, and there was actually no property under contract. He was just looking to buy in Texas.
Thank you. I have one last question because I'm right there with it, but I think I would add a cease and desist. Absolutely. But does the respondent have any other real estate related businesses in Colorado? Do we know?
Not from what I've seen. Now I mean, it's possible that there could be something that's unregistered, but from what we yielded in the investigation, it does not appear that there are any other companies under the respondent's name, or that the respondent would be responsible for overseeing.
Thank you.
So,
I also wanted to say, just before you make a motion, I believe the max fine can be $9,000.
Thank you.
So with that said, I'll make a motion that the board accept staff recommendations with the following amendments. Increase the fine to $9,000. Issue a cease and desist letter. And then along with the referral to law enforcement, provided the rest of the board is in agreement, I'd like to make a special note that this board feels that this respondent should be prosecuted to the fullest extent of the law. The reason I'd like to add that is because that then can become an exhibit that the prosecuting attorney can submit to the judge, which could be very helpful in that case.
I would second that motion.
All right, let's have a vote.
Can I ask
all
one
those in-
quick question or no?
Go ahead. Yeah,
Yeah, please.
Wasn't there something about 15,000 in restitution as well?
it is down there, correct.
Does that need to be part of the motion or no?
It's in the staff recommendations.
Okay.
But do we need to
Yes,
read all of that?
Dave, I intended for that to be included, yes.
Okay.
and board member, I just want to make sure, I want to say that potentially that amount that was paid was actually 16,000. Let me just double check for you.
Thank you.
No, it was 15,000. 15.
So
Okay,
to
great.
clean it up,
Yes.
do we want to just restate it to clean it up, our recommendation and our vote?
Sure, I'll restate. I would like to make a motion that the board accept staff recommendations with the following amendments. We will fine the respondent $9,000. A cease and desist letter will be issued by the Division of Real Estate. And then along with the referral to law enforcement, there will be a special note made that this board would like to see the respondent prosecuted to the fullest extent of the law.
Do I have
I
a
second the
second?
motion.
Second,
Let's make a vote. All those in favor say aye.
Hi.
Aye.
Aye. Vote passes. All right, let's move on to licensing matters.
All right. The licensing matter A is complaint number 2024-1823. This is an application. On June 20th, 2023, the applicant was convicted of unclassified assault. The applicant was sentenced to 12 months probation and a fine of $271. The applicant completed probation successfully and has paid the fine in full. There is no recommendation, and Investigator Tabitha Quintana is here to answer any questions.
Thank you. I'll open this for discussion.
Was there any prior criminal history other than this?
No.
Okay.
I was a little confused as to whether the applicant did or did not disclose this on the application. I think I saw some conflicting info on that and I couldn't figure it out. Was it disclosed?
I believe it was.
We can look at that for you.
And I do think, I thought I had saw that there was a domestic violence in 21,
actually, August of 20.
20.
Oh, so there was. Okay.
And then
Oh,
there was also something referenced in 12/20, I'm sorry, December of 2019 for an assault.
so
Yeah.
that was
Let me look at
2000.
that.
Or maybe that was her, rather, I'm sorry.
Yeah.
Yeah, that was the only thing that came up on the background.
I'm sorry, can you repeat that, please?
That was the only thing that came up on the applicant's background.
Okay, thank you.
Which was the,
The assault, the unclassified.
Yeah, give me just 1 second. I'm looking here. For whatever reason, my computer's not wanting to open anything, but let me answer the question as far as the application. Tabitha, I don't know, are you able to, nothing's opening on my computer right now.
Yeah, I'm having a hard time with my computer this morning as well.
Okay, it's going, it's just moving really slow. I'm trying to get into it here. I think we're having some system issues potentially.
if I remember this correctly, while you guys are looking, I think the domestic violence was actually self-reported in the application. And then we have this assault that was the current portion of it. But please correct me if I am wrong.
Okay, so there is a prior criminal history.
That's how I have my notes, correct?
Okay.
Okay, so, sorry, I was just able to open it. So, on the application, there was the guilty plea in 2021. There was a guilty plea that was disclosed in 2021. And that was removed because it was a misdemeanor that does not generally fall under the board's
And I
jurisdiction.
believe it was a deferred sentence as well. That's why I didn't list it.
Okay.
It
Okay.
was a deferred sentence, so it's no
Okay.
longer on his background.
So I would say, looking at this, that he did disclose criminal convictions, and then yes, I would just go off of the 2023 conviction that we have put on the report. If that helps answer your question.
So I noted that he hasn't had a job since 2019, and he did not have any letters of recommendation. And I'm sorry, I don't remember. Did he submit a personal statement or anything like that? I don't remember.
Look at the report.
We can look at the exhibit.
He supplied a written statement.
Oh,
Yeah.
okay, thank you.
He did.
Oh yeah, okay, here it is. Oh, right. Okay,
Exhibit 6.
that's right. Okay.
So given that there is a prior criminal history to this conviction, and in light of the guidance that we received earlier today from the AG's office, I would propose to the board that we consider denying the application until it is outside of the 3-year look back period. Had there not been a prior history, I think I would be recommending the opposite. But since there is, my feeling is maybe we wait this one out.
Board members, sorry to interject. If you do all decide to move forward with denial, you will have to go through the process that we discussed. So first off, identifying a potential basis for denial. It sounds from the board's discussion that the concern there would be the criminal conviction for assault. That would likely fall under 12-10-713 1N, which would be a discretionary basis for denial. And from there, you'll need to kind of go through those next steps. If that's where the board is leaning towards.
I wasn't leaning towards denial.
I was leaning towards denial myself. So, the other members of the board, how are you feeling?
I'm pretty torn on this one because, yeah, I don't like the evidence of previous violence. I do think it was kind of an extenuating circumstance, looking at the explanations of what had happened in the interviews and that kind of thing, what had happened in this particular situation. He has completed anger management and has done community service. Yeah, I'm really torn on this one.
And wasn't there, if I recall, on April of 2023, a verbal argument and push assault situation too?
That's
Yes.
the assault.
What's that?
That's the assault charge.
Then we have the domestic violence one too, right?
And,
I
That was
didn't
the
see the
deferred
domestic
judgment.
violence one.
and board members, I think the other charge was for a criminal mischief, I believe, and that does not fall under one of the identifiable criminal conviction bases for discipline. Just to interject.
So it was not domestic violence. The previous conviction. I'm sorry, that had the deferred sentence, that was criminal mischief, not domestic violence. Do I have this correct?
I have to look that up. I didn't add it because it was a deferred sentence and dismissed. So-
Yeah, I totally understand why it's
Yeah, we leave those off of the report just because since they are dismissed,
right.
it's really not something that we would put for consideration into the report.
Yeah, I understand that. That makes sense, but
Yes, in 2020, it does look like it was dismissed, but there was a domestic violence charge.
oh, it was, okay.
And then he's currently, it's a deferred sentence, deferred judgment too.
So the sense in which I believe this person's criminal history relates to the profession is that LOs are exposed to various circumstances where they're at the table with other people and disagreements can arise. And you need to know that that person is going to be able to maintain their composure in those types of situations. And what has me hesitant is that I'm not sure this applicant can do that. However, if within that 3-year period, there are no further instances of this person having problems maintaining their composure, then as speaking for myself, I'd be more than happy to approve a future application. That's my sense. And Anthony, I think that's what you were trying to drive us toward.
Never trying to drive you towards anything, board members.
So, okay, sorry. I know what you mean. I chose bad word choice.
So if the board wishes to go through denial, it must conduct. So the first thing you look at is when the conviction occurred. It's within a 3-year look back window. So there is no need to examine. Let me rephrase. So you would start your kind of analysis with, is the applicant unable safely to perform their professional duties? And it sounds like, based on the conversation that you all have been having, that you've kind of addressed that. The next inquiry would be those 4 rehabilitation factors. And just to remind the board, those factors are: 1, the nature of the conviction; 2, whether there is a direct relationship between the conviction and the licensee's professional duties and responsibilities; 3, the information produced by the applicant regarding rehabilitation and good conduct; and 4, the time that has elapsed since the conviction. I believe you all have kind of discussed the timing aspect. That seems to be one of the concerns. And I think briefly discussed that the applicant provided some information, written statements, I believe was mentioned. But if perhaps you could go into in a little bit more detail, the nature of the conviction and the direct relationship between the conviction and the professional duties.
And you'd like us to elaborate on that more?
If you wouldn't mind, please.
Sure. I believe the direct relationship between this person's offenses and the profession are that Loan originators are subjected to lots of situations where things can get stressful and unexpected complications can arise. And in those instances, they need to be able to maintain their composure. This particular applicant has a pattern of not doing that. So I believe that since we're still within the 3-year window, that justifies this board in recommending denial. How'd I do? Is that okay, Anthony?
I think that is sufficient. Thank you.
Okay.
I would second the motion.
So I have
Well, I guess it's not a motion at that point, but go ahead, Shirley.
in the past, we've also allowed people to withdraw their application versus our denying the application as kind of a, with a recommendation that says that, we would reconsider the application after the 3-year period has passed. So, because there's a difference between then somebody being denied and basically they're being allowed to withdraw. I just want to throw that out there as another option.
That's a great idea, Shirley. I would be in favor of that.
Same.
Right. Do you want to make a motion of it then?
And
Sure.
just,
yeah.
and maybe just to help clarify, so it appears that the bases for denial that you all have identified is 1210, 713, 1N. And the denial would be with the opportunity to withdraw. Just to clarify.
Okay, gotcha.
Okay.
Thank you.
Yep, thank you.
All right, I move that we okay, now I've lost it. That we the board, I move that we deny the application based on 12-713-1N with the provision that we allow the applicant to withdraw the application. And the board would reconsider an application after a term of 3 years.
And sorry to interrupt, board members. The board cannot necessarily dictate how often or frequent someone applies for a license. It would just be more, I would say, a comment in general that you would be more maybe willing to consider granting the license upon further rehabilitation or something along those lines. Sorry to interject.
Okay, so I just want to open it up. Does that change anybody's thought on allowing him to withdraw versus deny
No.
it?
Not to me.
No.
Yep.
Okay. All right, so I will make a motion that in complaint number 20241823, we deny the application based on 12-13-1N and provide the applicant the opportunity to, or the option to withdraw his application at this time and reapply at some point in the future. The board's recommendation would be that there be further rehabilitation and a period of 3 years before applying again, but that is just our recommendation.
Second.
Before we vote on it, though, I want to verify the actual site. It's 12-10-7131N.
Oh, I'm sorry. Yes. Thank you.
We did have a second, so let's have a vote. All those in favor say aye.
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 I am also an aye. Natalie, did you vote?
I'm a nay.
Okay, so we have 1 for a nay. So the motion does pass.
All right, licensing matter B is complaint number 2024-1839. This is an application. On August 17th, 2022, the applicant was convicted of disturbing the peace. The applicant was sentenced to 1 day in jail with credit for time served, and the case is closed. The applicant is a licensed MLO in Indiana, Oklahoma, and Washington. There's no recommendation, and investigator Quintana is here to answer any questions you may have.
Thank you, Sarah. Open for discussion, or is there much discussion on this one?
The only question I had was the requirements around reporting convictions of misdemeanors. Is there one or not?
No,
I believe it's only felonies.
right.
Okay. That being said, I'll make a motion to approve the application.
I'll second it.
All right, let's do a vote. All in favor, say aye.
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 And I am also an aye. The motion passes unanimously.
All right. Licensing matter C is complaint number 2024-2147. This is an application. On April 3rd, 2014, the applicant was convicted of felony use of facility of interstate commerce to attempt to induce a minor to engage in criminal sexual activity. The applicant was sentenced to 180 months in prison, 5 years probation, and restitution in the amount of $22,352.71. The applicant completed the prison term with a compassionate early release and is still on parole. The applicant is currently on a $100 payment plan and has a balance of $17,204.71. There's no recommendation, and investigator Quintana can answer any questions.
Thank you. Any questions on this, guys? Discussion?
Are the payments on the loan plan current, and have there been any missed payments or repeated late payments?
No,
Do we-
he has made payments of $500. He's trying to pay it off as soon as possible, so he is current and up to date on that. He's making overpayments.
It looks like he just recently started the overpayment though, one
Yeah,
payment
a couple
in
months
for
ago.
500. Yeah.
Right, a couple months ago. But he has
November.
he's made his $100 payment every month and has been consistent with that. It's exhibit 10 and 11.
So while it is very disturbing, it sounds like he's, paid his debt to society at this point, and obviously was released on based on his service and while he was in prison. So I'm intent to grant it, but open for discussion.
I have the same feeling. Oh, go ahead.
I feel that because a mortgage loan broker has significant contact with the public, which could include children, young girls, all that kind of, I cannot approve this application. I feel that in spite of the fact that time has passed, there is still a potential danger to the public in having this person be licensed as a broker and be working with the public.
I concur with Shirley. I am particularly sensitive to sex offenses where the victim was a child. And yes, this is a public facing role, and we are still within that 3-year period. I believe this person was released in 2023, March 1st of 2023. And I do believe there's a direct connection between this person's offense and the kind of work that they would be performing. And given the severity of the offense, I would like to see an application from this person in the future once we're outside of the 3-year time window. But while we're within it, I cannot I cannot approve this application.
I would agree. I think as a loan officer, you're in many cases in the remote work lifestyle that we have nowadays and working from home, many times appointments are taken at clients' personal homes, and that's putting this person in the personal home of the general public. And I would agree that I would not be voting for approval.
That's a great point, Natalie.
I actually am kind of torn with this one. He's done his time and everything like that, but I can't get over the 3-year look back to me as well. Rehabilitation is not overnight, but it was a significant sentence. And being in the roles that I have in my licenses, I am just like board member Broderick, very, very, and I guess it's something that really pulls on my heartstrings when it's included anybody that's a minor. So I would be of the same thing as being a negative on the application for me as well.
I mean, and added to that, this was not a one-time thing. I mean, there were multiple individuals involved, multiple repeat offenses, but I just can't approve it.
Board members, sorry to interject, just one point of clarification. So that 3-year look back window, so if you're within that 3 years, then you don't have to determine whether the conviction is directly related to the profession. So if for instance, an applicant applied and they're a year or two outside of that 3-year look back, there's just an additional inquiry that you all will have to perform, and that would be determining if the conviction is directly related to the profession. Just wanted to clarify that the 3-year look back period doesn't necessarily preclude you from things. So.
Okay, thank you. And I think the discussion has been that some of us feel that it is directly related to the profession and are very concerned about this.
I would absolutely, as being a licensed loan officer, I go to meet people and their families are there, and I'm at their house and I'm meeting them everywhere. And I definitely think it's a direct relation to it.
So if we're going to deny, we need to base it on something.
Would
No, I
you
think
guys
that's
want
what
to
he said.
deny or withdraw?
I would go with deny on this one. Sorry, Natalie, go ahead.
I think what Attorney Lally was saying is that because it's within the 3 years, we don't have to, other than we just have to say it's tied because he's could potentially go into other people's homes, and then that would be our basis for the denial, I believe, right?
Yes, given the circumstances of going into people's homes, the board, it sounds like we are worried about this applicant's ability to safely perform their professional duties, which is the criteria that we need to consider. And so, yes, that would be the basis, I believe.
Board members, sorry to interject again. I believe you'll also need to address those 4 kind of rehabilitation factors. I believe you may have already done so, but just a reminder, nature of the conviction, which I believe you all have discussed, whether there's a direct relationship between the conviction and the professional duties. I believe you also have discussed that. The information provided by the applicant regarding rehabilitation, I don't know if there's really been much discussion there. And then the final component is the time that has elapsed since the conviction. And in this case, that would be the conviction date was
2014.
Yes, thank you. And as for potential bases for denial. We flagged potentially 1210, 713, 1N.
Yes.
As a basis.
Just to have a clarification, on that with the 3-year look back, I thought it was the date of conviction or release from incarceration.
Yes, there's two different timing kind of look back. So the look back period is correct. The rehabilitation factor focuses on just when the conviction occurred.
Okay.
So there is some overlap, or there could be some overlap. Not so much here as because of the incarceration portion of it.
Thank you.
And it said that he was released to a halfway house. Do we know if he's like fully released yet?
Oh, that's a good question.
Let me check on that. I believe he's still in the halfway house. Let me just double check on that.
Okay.
Yeah, I mean, I think either way, though, and correct me if I'm wrong, Anthony, I mean, his sentence has been completed. He's been released. I mean, I know that he's, still on probation, obviously, but.
But a
Yeah,
halfway house wouldn't be released. Like that's still serving out a sentence.
Well, the sentence would not be completed if he's still in the halfway house.
Right.
Yeah, sorry. I guess what I meant was his jail time. But I see what you're saying.
Well, I would say that based on rehabilitation factor 2, that we've established there is a direct relationship between the conviction and the professional duties and responsibilities. I believe that justifies denial.
I think we all are in agreement to that.
Yeah.
I'll make a motion to deny.
And based off of
well, for me, it's with that we're still within the 3-year window, and that rehabilitation factor 2, that there is a direct relationship between the conviction and the licensee's professional duties and responsibilities. That's why at this time I would recommend denial. With the passage of more time, if we were to see another application from this person, I might, speaking only for myself, be inclined to go the other way, but not right now.
So we would probably, again, go back to the portion of, do we want to withdraw the app or deny? If we deny, I believe that's forever. It shows as a denial, and typically you cannot reapply with a denial. Also,
Okay.
if you, in that statement, state the possible violation statutes, if you can. Am I
Sure.
correct? Am I correct, Mr. Lally?
Yes, and based on your all's discussion, I believe the violation statutory site would be 1210 713 1N.
Okay, I'll restate the motion. I would like to make a motion to deny the application, giving the applicant the opportunity to withdraw based on Colorado revised statute 12-10-713 1N as in Nancy.
Anybody second?
Well, I'm concerned because I would prefer a flat out denial.
And just to make a note, he was released from the halfway house. He's on parole, but he has been released.
Do you know when he was released?
On the March 1st, where is it, of 23.
Well, he said my temporary residence effective on that day will be halfway house located at
but
such and such address.
yeah, let me see. I just lost
So
it.
the reason I would ask that is just because how long has he been out in public and around people and having the temptations? Like, has there been enough time passed that would show that he isn't going to
And he is
make
on
the
a
same
term
mistake?
life.
Huh?
He is on a term life for registered sex offender as well.
Yeah, I don't know that
So-
that saves much, but if he hasn't, I
He's-
mean, released in March of 2023, we don't know how long he was in the halfway house. So let's say he was in the halfway house, I mean, even just a year, that's only a year out in the open public, with temptation. Again, like there's not enough time to prove that he's not gonna recommit the same crimes.
And Shirley, if I heard you right, I think your feeling is permanent denial. Is that where you're
Correct.
going?
Yes.
So you're not at all open to ever allowing this person to serve as a loan originator, ever?
Never.
Okay.
And he is currently licensed in California, correct? I think he got a license in September of 2023.
I believe he was, but
So
I'm
we
with
were looking
Shirley. I would go with never.
He is currently licensed in California.
And,
Yeah.
and board members, a denial without the opportunity to withdraw does not prohibit the individual from applying in the future.
Right.
All it does is it just reflects on the NMLS that there was a denial. And I believe most states require that to be reported to any, the license regulatory body that handles that.
Okay, so if we deny, he could reapply at some point in the future. Okay, that's great clarification. Thank you.
thank you. So I guess we need some more conversation because it sounds like we're pretty split.
Yeah.
David, what's your thoughts?
Oh, there's been good discussion. I'm very, very torn. I got a compassionate side of me that wants to give somebody a second chance. But I've heard, that was my first inclination when I started the conversation. But I definitely can see the overall concern, and if he does have the opportunity after some time, he wants to come back in, that gives him the opportunity. I'm not opposed to what is being proposed right now.
So I'll retract my motion and remake a motion that we deny the application with the understanding that the applicant would have the opportunity to reapply, but that this denial will always be disclosed. And in my mind, that would simply mean that the applicant is just going to need to make a very compelling argument for why the board should approve the application. So with that said, I'm okay making the motion to flat out deny.
And based off of a statute?
Based off of Colorado Revised Statute 12-10-7131, N as in Nancy.
All right.
I second.
Second. All right. Take a vote for it. All those in favor say aye.
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 I am also an aye. The vote passes unanimously.
The next licensing matter is matter D. It's an application, complaint number 2024-1946. On April 25th of 2022, the applicant's California insurance license was revoked due to his criminal conviction on January 11th, 2022 for illegal possession of a firearm within 10 years of a misdemeanor. On January 18th, 2024, the applicant's mortgage loan originator license application was denied by the state of Georgia. The denial cites not demonstrating financial responsibility, character, and general fitness to command confidence in the community. The denial also cites a failure to provide requested information. During the review, division staff identified 6 criminal convictions in the applicant's criminal history. The applicant has provided proof that the 6 criminal convictions were expunged, the case is set aside, and the guilty plea is dismissed. He is currently licensed in 6 states, and we do not have a recommendation.
How in the world do 6 criminal convictions get expunged? That's just my thought there. I'm sharing with all of you.
I wonder if some of that has to do with the age at the time of offense. I didn't speak with the courts to get confirmation on how something like that is accomplished, but that may be one of the factors. But yeah, don't have an answer for you on that. I'm sorry, Board Member Thielen.
I wondered the same thing, Shirley. That to me, that was a red flag in a way. But there were still 6 convictions. And I appreciate that this applicant truthfully disclosed his history, but I am hesitant because of the number of convictions and that another state has recently denied his application. So me personally, I'm leaning toward denial, but I'm open to being talked out of it.
I know in Georgia, I believe they have a credit requirement, which Colorado does not have, and so we can't really kick it because of that. But my problem with it was there was a lack of information received when they were asking questions as well. So a lot of this comes back to we've talked many times in this board that, hey, we've asked you for this, you haven't sent us this, or all the investigators reach out to you, you don't respond. If we don't have the information from you, we can't make correct information, the decisions, and that's going to directly reflect on you. So to me, all of this is just adding up to somebody. I mean, obviously we look at this, the nature of convictions, which we don't know, which that's not a big deal, but the relationship to the professions, if you're having criminal convictions and then you're also not working with a state that's asking you for information, that's something that we've always looked down on in the past, in my memory.
He did provide information. I'm not sure if there was something that we missed, but he was responsive. So I don't want to give the impression that he wasn't working with us.
I believe that was in the Georgia.
Okay, gotcha.
So it's not with us, but it's
Okay.
outside. And
Understood.
if you cut ties with something, you just go, whatever, yeah, gone. I don't need to worry about that. I'm gonna go somewhere else, right? So just kind of my thought process with it.
Okay.
Well, in his personal statement, he says that his turning point was March of 2019 when he got married. Okay, but there's something in 2022 when he was illegally possessing a firearm. So that's a little bit in conflict with what he has said in his statement.
Board members, sorry to interject, but I believe all 6 of the criminal convictions were expunged, which means the cases were set aside and the guilty pleas were kind of dismissed or withdrawn. So I don't know if there's really a conviction to hang your hat on, if that is the basis or that is the concern of the board.
So something we have done in the past as well, other board members, is we've given a probationary license and made sure that somebody was above them watching over them as they did theirs. And we typically did, I think we did about 180 days. It's something we could do as an option. I personally was a no on this one due to unworthiness and incompetence to me, but I don't know if that would stand up, but I just want to know your guys' thoughts.
Is that an option?
I don't know if we can, but that's obviously just for discussion.
I thought that we're going to need clarification on this because my recollection was that that option is available for real estate brokers, but not for mortgage brokers.
I'm
I
pretty
could be
sure,
totally wrong.
I'm pretty sure we did that within the last year for a couple of people in our system.
Okay. Is Marsha on?
Yeah, I
Is
was gonna
that-
say that may be a question for the folks at DRE. I can say that there was one probationary license that I recall that was issued by the board. It did not have supervisory conditions attached, but again, I'll defer to DRE.
I think it was very hard to administer the probationary license because there's not somebody that actively researches those and does that. That's what if I remember right.
I think that's right. Yeah. Okay. That makes sense. So basically what I'm hearing, what I'm understanding is there's not, the previous convictions do not provide a legal basis to deny this application.
Correct.
I think that they do reflect, they do give us information about the person's character. And again, they're going to be in the public, working with the public, and that's a concern to me.
And we can deny based on that, correct?
I would think so with
Anthony.
So board members, oh, I'm sorry, Nicole, please, I didn't mean to interrupt.
I was just going to ask you if you could answer that.
Yes. So I think what board member Thielen is alluding to is in 1210-711. Let me find the exact provision. So section 1, subsection G, the board may deny an application for a license if the licensee has not demonstrated financial responsibility, character, and general fitness to command the confidence of the community and to warrant a determination that the individual will operate honestly, fairly, and efficiently, consistent with the purposes of this Part 7. I will note that the financial responsibility, character, and general fitness to command the confidence of the community all have to be established.
Yeah.
And also make a determination that the individual will not operate honestly, fairly, and efficiently. So a lot of subparts to keep in mind there.
Okay, so oh, I'm sorry.
No, please.
So the financial responsibility was questioned by Georgia when they denied the license. Obviously, we don't have access. Nothing was run. That's not a Colorado state requirement, but it does. The fact that the Georgia license was denied does, based on financial reasons, that would lead me to believe that there was some justification, in that regard. Now, where's the rest? There it is. Character, we've talked about general fitness to command the confidence of the community and to warrant will be operating honestly, fairly, and efficiently.
Board members, just to give you a little background though, so the financial fitness aspect, I believe, is part of the SAFE Act, and the way that Colorado dealt with it is the ability for a mortgage loan originator to obtain a surety bond. So that's how we deal with financial fitness. The one thing that I would flag for you is this criminal offense is similar to one of the complaint matters. So you may want to just kind of keep that in mind for consistency purposes as how you deal with it. Like it was complaint matter A, that he would get to keep his license as long as he completes his criminal sentence. I mean, it's a weapons offense, but just something to keep in mind. And I think you had a question about probation. If you do a stipulated agreement where he's allowed to have kind of a restricted license is what it would be. You would determine the period of time that he would have this restricted license. And typically the language in the restricted license is they're not supposed to have any additional criminal offenses.
I like that.
I would want to point out that he did make a statement on the Georgia denial on page 31 of see, it looks like it's exhibit 3. But yeah, he did point out that that was essentially a result of past due credit card accounts. So he did provide some detail on that denial.
Yeah, I remember that. I think he said he was current on his mortgage and
Our payment.
yeah.
Yeah, he said that he had fallen behind on credit card payments and basically was not able to secure a payment plan.
Right.
Yeah, says that he's now up to date on his home mortgage and all of his auto loans.
And I want to just clarify, his California license was revoked, or was that the insurance license?
I believe that was insurance, but let me double check for you.
Thank you.
I think it was insurance.
I think so. Oh yeah, here it is. Yep. Okay. Thank you.
And what was the basis for the California insurance being revoked?
So that was the criminal convictions. So basically, he was issued a restricted license in July of 2005. Then in February of 2008, it was the insurance license was revoked and then reissued with restrictions. And that was because of his failure to disclose the 2005 criminal conviction. Looks like the license restrictions were removed in June of 2012, and then in November of 2018, the license was again revoked for his January of 2018 conviction. Basically, it was reissued, restricted again, and then he had the final revocation in January of 2022, and that was for the most recent conviction. So they were all a result of criminal convictions, but again, they've all been dismissed and set aside at this point.
So what I'm hearing is that we would have justification to deny the application under 12-10-711-1G based on the findings of 2 other licensing authorities in 2 other states. That's what I'm hearing.
But I don't know if that denial would actually be, or if you could execute it, if the denials or if the previous license discipline is based on criminal convictions that are now dismissed. I'm not sure if that's a strong enough basis.
That's probably a question for Anthony.
But Georgia's was not, though.
Georgia's was a financial.
Georgia's was financial for the card, which he would probably argue are now current.
But did we verify that? I know he's stating he's current, but do we know that?
So we don't have a current credit report to show because we don't. We're not in the as far as our process of reviewing the applications, we're not looking at their financial background the same way that other states are. Certainly, I could follow up with him and ask for something if the board wants confirmation on that. But just as a matter of procedure with our application process, we're not looking at the financial background the same way that some other states are.
Now, I think what we could do, though, as it sounds like we're all in the same thought process, the relationship to profession, if you're guiding someone in the most important purchase of their life and they have been denied from another state for the financial portions of it, that could be something that we could tie into that. Are we correct with that, Mr. Lally?
I think as Director Waters mentioned, historically, it sounds like what the board does or how the board treats financial responsibility is to determine is to require them to pay surety bond. Don't want to put words in Director Waters' mouth, but I believe that's what she stated is kind of how the board historically has looked at financial responsibility. Oh,
If he has a surety bond?
Yeah, I think that that all has to be in place when the application is done. But let me check our system and see what we have on record for right now.
So if you got denied a surety bond, you wouldn't be able to have an active license.
Okay.
So it's the ability to acquire one.
So he's also licensed in California, Minnesota, New Jersey, Pennsylvania, and Texas, with New Jersey being approved conditional as well. I think that makes it a little more difficult.
It does.
It looks like we have new surety bond and errors and omission as of October 21st of 2024. So it looks like those are in place right now.
And it's effective currently?
Yeah, well, our system is saying that the surety bond expires March of 2025 and E&O expires August of 2025. So
Thank you.
Well, I think maybe we go back to what Aaron originally proposed is a conditional type approval. I would be open to that. Other thoughts?
Yeah.
I think that's the only way we can go.
Yeah.
Not really sure how to make a motion on that.
I don't remember how we did that either.
So board members, it would be issuing a probationary license, and then if there were terms of the probation that you wanted to include, you would just include them. Based on the board's discussion, it kind of sounds like there were two things that the board was concerned about. One being any commissions of future criminal activity, and the second one just complying with licensing law. So perhaps if the board wants to go that route, those are two conditions that maybe can be imposed if those are the big board's main concerns.
So,
and we need to know how long you want
that
the
was my next
restricted
question.
license.
Yeah. So we could make a motion with those two things, portion of that, the future commission or comply, and then we'd give a future date and say, for example, just 4 years or 3 years or whatever that may be, and make sure nothing happens in between there. If something did happen, it would come again to the board, and then we could approve, deny, or do something further. Correct?
So if he violates the license law or has another criminal conviction, we would bring it back to you likely as a STIP violation for the restricted license.
Okay. Thank you for the clarification.
All right, let's talk about the period of time. Let's make that determination. What is everyone's thought?
My sense is for matters of consistency, 3 years, because that seems to be what matters to the legislature, but I'm not married to that. I just thought if the legislature says a 3-year look back, maybe we do the same thing.
I would agree with that. I think 3 years from today's date, that would put us clear into 28. If something was going to happen, it would happen in that time frame, and hopefully it doesn't.
And board members, it'll be 3 years from when the stipulation is executed.
Okay.
So we wouldn't go from today's date.
Perfect. Does that sound good for everybody? So
That sounds right.
anybody want to make a motion with that?
I move to approve with conditions. Number one, no violations of licensing law. Number two, no criminal violations. I guess it has to be at the felony level or above, correct? For a period of 3 years from the date of the stipulation.
I second the motion.
All right, let's have a vote. All those in favor say aye.
Aye.
I am also an aye. The vote passes.
Woo.
So now we're moving to ESP matters. Ms. Elder, do we have anything? It shows none on here.
Depending on something come up this morning, and I don't think she's with us, but there aren't any ESP matters. You just have a attorney general matter as far as the case is concerned.
Excellent, thank you. We can just turn that over to the Attorney General then.
Yes, thank you, board members. So Attorney General Matter A, training regarding license application with criminal convictions. I believe we've already addressed that and provided that legal guidance. So just moving on to Attorney General Matter B, which involves OAC case number MLO 2023-0003. This is a settlement proposal in an active case. The terms of the settlement are, sorry, lost my notes. The terms of the settlement are relinquishment of the license, which will not be treated as a revocation, agreement never to apply for a Colorado MLO license, public censure, and a $25,000 fine, plus the mandatory 15% statutory surcharge. We have a signed offer from the respondent, and that signed offer reflects those terms.
I'm actually, I read through it and I totally agree. I think it's a good settlement to me.
I agree.
Same.
Based on prior discussion, I'll make a motion to approve the recommended settlement agreement.
I second.
Yeah.
Second.
All right. Do
Sorry.
we have a vote? Let's do a vote. All those in favor say aye.
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 Natalie? Did we lose Natalie?
I was on mute. Sorry, I.
Oh, sorry. Aye, okay. And I am also an aye. So that passes unanimously. All right. I think, is that everything we had on there? We did talk about loan officer. Oh, sorry.
Unless you have second thoughts about agenda items for your March meeting.
Do we have anybody want anything to add to the agenda for March?
I do not.
You know, okay. Well, I think everything is, I think we're over then. So this is Aaron Saladay, the chair of the Colorado Mortgage Loan Origination Board. It is 11:47 on January 15th, 2025. And we call this meeting adjourned. Again, so we need to vote on it.
Yes.
Yes.
Thank you.
So everybody vote on that. Say aye.
Or a motion
Aye.
first.
Or a
please.
motion. Sorry,
Oh,
a motion.
I move to adjourn.
I second.
All right. Well, thank you all for all your work. So everybody's
Y'all
approving
gotta
that, say
say
aye.
We
Aye.
didn't do the vote. I apologize. Sorry to be the squeaky wheel, but we didn't do the vote, just the
All
motion.
those for approving it, say aye.
Aye.
I.
Aye as well. Thank you all. Thank you all for your work and enjoy the new year. Happy New Year.
Happy New Year, everybody.
See you,
Thank
everybody.
A couple of months. Bye.
Aye.
Stay warm.
Thanks.